Imagine you move from a place where you lived all your life. Imagine you move and you leave all your children and wife. Starting all over again, but no one you know is around. Well, they didn't have to imagine. They built it up from the ground. How does it sound? Not easy cause it isn't. Could have phased them, but it didn't. But the raid bond, that's a winner. And they ran straight to the finish. You get to know them up close and personal. Wait, just give me a minute. Welcome to the front row. Can I get a drum roll? Intentional. We may be immigrants, but we are still intentional. We are dependable. It's just that set the bar, but still the best of all. We are intentional.
Welcome to the Intentional Immigrants podcast. I am delighted that you're able to join me here today. Today's guest will be Sarah Coderre of Bow River Law. She will be sharing with us some tips and tricks of how to navigate the legal landscape here in Canada, and especially in the province of Alberta. This is a two-part series, and Sarah will be sharing with us some terms, some scenarios that exist, and how to circumvent or find your way around those circumstances. Hi, Sarah.
Good morning, Commander.
Good morning. Welcome to the Intentional Immigrants podcast. And today, I am happy to have you as my guest in your full capacity, wearing your hat in all its glory as a labor, employment, and human rights lawyer. What tips do you have for my listeners? An immigrant coming into Canada, what tips do you have for us?
Absolutely. So I think the first thing that I'll do is just sort of broadly explain the different sorts of issues that people come to me with. And these issues impact people that may be newcomers to Canada. They may be people who are not brand new, but have been in Canada for a couple of years, have never had to deal with anything involving the law besides their immigration stuff. And now they're dealing with an employment law matter. And so just generally, the sort of work that I do as an employment law lawyer falls under a couple of different categories. So the strictly speaking employment law stuff, that's going to apply to people who are not unionized employees. So this may happen, things may happen where, for example, you may be terminated from your employment. You don't know what to do. You're offered some sort of severance package or something from your employer. They want you to sign something in exchange for some money. You're not sure what you should do. That would be a time that you should come and see an employment lawyer.
Okay.
Another time you should come and see an employment lawyer again is if you're non-unionized, you've been accused of doing something wrong in the workplace. And the company is saying that they want to either investigate you or they want to fire you. That would be another time that you should come and speak with an employment lawyer, because your rights in employment law are very broad as an employee, and it's important that you understand what those are, and we'll get into those a bit more in a moment. Another time that people come to see me is when the workplace has become toxic. So they're being subjected to bullying and harassment in the workplace. They know it doesn't feel right, but they don't know if this is just the way it is in Canada. If they just have to put up with it, if they should be grateful they have a job, but they're being either verbally or physically maybe humiliated in the workplace or embarrassed or bullied and harassed. And it's important to know again that there are things that an employment lawyer can do to help you.
Okay.
Shifting over to human rights, this is a really important area of law, and basically every province in Alberta has its own human rights legislation, and then federally, the government has its own Canadian human rights legislation as well. And these different pieces of legislation may apply to you depending on where you live and depending on where you work. So if you work in an industry that is federally regulated, meaning you work for a bank, you work in telecom, you're doing work that maybe crosses over boundaries in the province. So for example, you're working for a pipeline company and those pipelines are going across provincial boundaries. You would be a federally regulated employee. The Canadian Human Rights Act applies to you. Okay. If otherwise you're just sort of working in Alberta, you're working for a local company here, or even a national company that's based in Alberta, the Alberta Human Rights Act would apply to you. The important thing about the Human Rights Act is that it specifically states that no one can be discriminated against on the basis of color, race, ancestry, place of origin, religion, age, sex, your gender, your family status, and a number of other grounds. And so if you feel that you are being treated differently in the workplace, because of any of those characteristics that you have, you may have a human rights complaint. And that's, again, an area that I would be able to assist you in. And then finally, with respect to labor law, this applies to people who are unionized employees. So you know if you're unionized because every month off your paycheck, you're paying union dues to the union. And then the union is the organization that represents any complaints that you have to the employer. They're dealing with you to help resolve those things. And they kind of act as a liaison with your employer. There's not a lot that I specifically can do in a unionized environment if you are a unionized employee. However, because the union has to work with the employer to resolve those issues that you may have with your employer. But if you have issues with the union, that is where I can get involved. Because if your issues with the union, if you raise a complaint with them, they're not taking it seriously, you can't go directly to the employer. They're going to say, well, deal with your union and we'll talk to them about your issue. So if the union is not representing you, that would be a time that you should come and see me. So I guess just to take a step back to the beginning, when we're talking about employment law, I can give you a couple of scenarios that I think, maybe common ones that new immigrants are experiencing. And then we can talk about, what their rights under employment law would be. So
sure, go ahead.
So let's pretend, for example, that you are a new Canadian to Canada. You've come over, you're on a work visa, so you have skills. You applied to come to Canada because you saw a job application. The company said, yes, we'll sponsor you. So they brought you over. While you are here, you are given an initial contract, you sign off on it, and then a few months later, they give you a different contract to sign off on. The new contract changes your pay, it changes your title, you're not sure what's going on, your performance evaluations have been good up until that point, but it seems like the company is not treating you fairly. That's an employment law issue, and it's actually called a constructive dismissal, where the company, through their behavior, they're changing a fundamental term of your employment, like your salary or what you do for a living, and they're foisting this change on you. And they're basically showing you that we don't really want to have you working here anymore, because no company is going to do that if they value you as an employee. A lot of people feel like, well, I'm stuck. I'm here in Canada. I sign on with this company. I don't have any options. You absolutely do have options. The immigration piece of it can make it a bit more tricky, but there certainly are routes that we can take involving Immigration Canada in dealing with the labor situation that you've got and the work permit situation. But just strictly speaking, your employer in Canada does not have the right to just unilaterally change terms of your employment without giving you notice and without giving you what's called further fresh consideration for those changes. So if you came over here and you were in a management position and now they're demoting you, from that management position to a non-management position, that would be a constructive dismissal unless you've agreed to that change. And so again, some of these changes, if it's a matter of how many hours per week you're working, it's kind of flexible and you don't really care, you may not want to make a big deal about it. But if it's something as significant as a management title, which is going to have an impact on your career going forward, that's when you would want to speak with an employment lawyer about that situation, because the employer is not allowed to do that. And so oftentimes what we will do is we will write a letter to the employer saying, listen, we understand that this change has been made. You're not allowed to make this change without this employee's consent. They don't consent to that change being made. And so now the employer has some options. They can either dial back that change, or they can try to end your employment without cause. And if they try to end your employment without cause, there are going to be some significant amounts of compensation that are owed to you as an employee, particularly when they're doing it in this context where they brought you from your home country here under the pretext of you would be a manager at this company. So the bottom line is, when you're in Canada as an employee, you have rights that are designed to protect you, because the courts here recognize and understand that there is a huge inequality of bargaining power between an employer and an employee. An employer can basically do whatever they want in most cases, and the employee is usually just grateful to have a job. So they're not going to push back. They're not going to fight back in a lot of cases. And that's not unique to immigrants to this country. A lot of people, especially in this economy, feel like I shouldn't complain, or it's the Canadian way to not raise a fuss. So they don't want to necessarily raise a fuss. And when things like that are happening at work, where changes are being made to your employment, it's not fair to you. You've never been consulted about these changes. You don't agree with them. That would absolutely be a time to come and speak with an employment lawyer.
What about if you've already signed the document?
So if you've already signed the document, even still, we can talk with your employer about those changes and look to have them reversed, because part of the issue is looking at how was it signed? Where was it signed? Were you given the document given a whole month to review it, you thought about it, mulled it over, decided to sign it, then you might be stuck with it, even though technically that might be a constructive dismissal. But if they gave it to you on your lunch break and said, we need this back by 1 p.m., and if you don't sign it, you can't keep working here, well, what are you going to do? You feel like you have no choice. So you're under duress now, and you sign it. Any document signed under duress is going to be suspect when it comes to the courts. They're going to look at that and say, well, is it really enforceable? Did this person truly freely enter into this agreement? Because even though there is this inequality in bargaining power between employer and employee, the courts have really tried to tip the scales as much as they can in favor of the employee and deal with that inherent inequality. And one of the ways they do that is say, when it comes to contracts, in order for it to be valid, in order for it to be enforceable, both parties entering into it have to be doing it freely. So usually if an employer is smart, they'll have a clause in a contract that says, I, such and such employee, have signed this of my free will voluntarily, there's no promises that have been made to me that are inducing me to sign this or something like that. Mm-hmm. But a lot of employers, even large companies that you think would be sophisticated, oftentimes just sort of ram these contracts through without following proper procedure. And so even if the terms of the contract might be enforceable, it's the way in which it's rolled out. If they give it to you with no notice, consideration is an aspect of contract law that's necessary. So when we talk about a valid contract, we talk about having an offer. Somebody has to accept that. Then there has to be consideration. The offeror, in most cases, the employer has to give the employee something for accepting that contract. When you first sign on as an employee, the fact that you get a job, that's the consideration. The fact that you're getting this employment wage, that's a consideration. But if you've already been at the company for 2 years, and now they try to give you a new contract, well, they can't try to say, well, you keep having your job now, that's a consideration, because you already have the job. So they have to give you something in addition to that. So some companies will offer, signing bonuses for new contract terms. They might roll out a new bonus program that you get to participate in if you sign the new contract, those sorts of things. So as a new employee in Canada, it's really, really, really important that you understand some of those basics around contracts, but it's also important that you understand your basic rights and entitlements. So just to step back a second, in Alberta, the governing legislation for all employees who are not unionized is the Employment Standards Code. That document can be found online just by Googling Employment Standards Code Alberta, and it outlines the bare minimum standards that employers have to follow. So just because something's in the Employment Standards Code, that doesn't mean that that's all you get from the employer, but it means that they can't give you less than that. So it outlines the amount of vacation pay you would get based on how long you've been with the company for. It outlines in the event of a termination, what's the minimum amount of notice they'd have to give you to terminate you if you hadn't done anything to cause that termination. It outlines your entitlements for things like overtime pay. What sort of is the multiplying factor on that? Is it time and a half? Is it something different? It's really important to look at that. And the Alberta government actually has a great website when it comes to employment matters that's very user-friendly, that helps to explain what's in that legislation for people. The other piece to understand is the common law. So the common law is not written down anywhere in any statute or any act. This is a law that's been passed down by the judges over the various years as cases have come before them in employment law matters. The common law says that if you are an employee, you are entitled to have a reasonable notice of termination unless you did something to lead to your termination. Reasonable notice of termination is more than the termination notice in the Employment Standards Code. That's huge. So for example, if you've been a manager at a company for 5 years, Employment Standards Code would say you're going to end up with 4 weeks termination pay. The common law might say that you might end up with 3 times as much as that. You might end up with 3 months, 4 months, 5 months, 6 months. The reasons why you might end up with more is because the courts say we have to look at you as an individual employee and decide how long is it going to take you to find another job somewhere else. So this is why every time people get severance packages, I really, really stress they need to come and speak with an employment lawyer, because the employer may say, oh, listen, Employment Standards Code says we only have to give you 4 weeks. We're going to give you 2 months. And you're thinking, wow, 2 months, that's double it. The common law might actually give you way more than that, but you don't know that. And the company isn't going to tell you. They don't have an obligation to disclose that to you. They want you to, leave the company, and they want to pay you as little as possible, because for them, it's all about the bottom line. So it's important to understand that you have those rights. You have rights in terms of how you're treated in the workplace as well. You have the right to be treated with respect and with dignity. even if that's not written in your contract. That's something that's implied in every single employment contract. The courts have said that employers have to treat you that way.
Thank you to the persons and websites who made this podcast possible. Sarah Coderre of Bow River Law. Xavier Anderson for providing music. Until next time, I'm your host, Yolanda Jack, reminding you, he who watches the wind will not sow. He who watches the clouds will not reap. Ecclesiastes 11, verse 4. You were born for greatness. Step out into your greatness so that mankind can benefit from you being here. So long, until next time.
Intentional. We may be immigrants, but we are still intentional. We are dependable. It's just that set the bar, but still the best of all. We are intentional.